Background on Roe v. Wade. A woman named Norma McCovey filed a lawsuit against the District Attorney of Dallas County, Texas. She used the name Jane Roe to protect her privacy during the highly publicized case. Norma McCovey was the plaintiff and Henry Wade was the defendant. Norma McCovey had previously given birth to 2 children and given them both up for adoption. She wanted to have an abortion to terminate her 3rd pregnancy, but was refused because it was not a medical emergency. The law in Texas and Dallas County was that a woman could only have an abortion if the pregnancy was life-threatening. Norma McCovey, however, believed that a woman had a right to an abortion at any time during the pregnancy and that a woman had the right to terminate the pregnancy in any way they chose. Before Roe v. Wade, only 4 states had legalized abortions. Those states were Hawaii, New York, Alaska, and Washington. The first was Hawaii, but they also said that only residents of Hawaii could have an abortion. Next was New York, and New York said anyone that visited, and it was not limited to only residents. There was also a movement in the 60s to ban contraceptives. The Supreme Court had previously ruled against the banning of birth control to married couples and later ruled against the banning of birth control to unmarried adults in 1972. The constitutional question being discussed in the case Roe v. Wade was, does the 14th Amendment's right to privacy protect a woman's right to an abortion? The 14th Amendment includes the Due Process Clause, which states, "Nor shall any state deprive any person of life, liberty, or property without due process of the law." Texas had been criminalizing abortions, and the Supreme Court needed to rule whether the criminalizing of abortions was unconstitutional and violating the 14th Amendment. Hypothesize. We hypothesize that SCOTUS ruled that abortions were protected by the Constitution. The Supreme Court had previously ruled that banning contraceptives was unconstitutional. They had done this on 2 different instances, the first being that contraceptives could not be banned for married couples, and the second in 1972 when they ruled that contraceptives could not be banned for unmarried adults either. Women's rights had been highly discussed during the 1970s, and major changes were happening within U.S. society. U.S. society was changing greatly during the 1970s. Women were no longer part of the nuclear family. After the 1940s, women were forced out of being the Rosie the Riveter type women and were now I will stay home and cook and clean and take care of the children while my husband is away at work. Now, this didn't speak for all women, but this was most women within society. A change to the 1970s was now women were becoming a greater part of society, a more powerful group of people within U.S. social groups and norms. They were starting to try to break the gender discrimination within education and the workforce, and the SCOTUS could have realized this, and this, we are hypothesizing, that this could have influenced or at least been recognized while they were ruling this case.
By a majority ruling, the justices on SCOTUS determined that women have the right to get an abortion. The only 2 justices that did not agree with this were Justices William Rehnquist and Brian White. The question they were asking was, does the Constitution recognize a woman's right to terminate her pregnancy by abortion? The decision was yes, the Constitution does protect this right. The justices on the Supreme Court determined that abortion is constitutional according to the Due Process Clause, which is a fundamental right to privacy, and this is in the 14th Amendment. They concluded that this protects a pregnant woman's choice whether or not to have an abortion. They also used the 9th Amendment, and the 9th Amendment protects the unenumerated rights not blankly stated in the Constitution, and they said this to protect the privacy of a woman since it's not exactly stated in the Constitution. The principal thrust of appellants' attack on the Texas statutes is that they improperly invade a right said to be possessed by the pregnant woman to choose to terminate her pregnancy. Appellant would discover this right in the concept of personal liberty embodied in the 14th Amendment's Due Process Clause, or in personal, marital, familial, and sexual privacy said to be protected by the Bill of Rights or its penumbras. The Constitution does not explicitly mention any right of privacy. The court has recognized that a right of personal privacy or a guarantee of certain areas or zones of privacy does exist under the Constitution. This right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action as we feel it is, or as the District Court determined in the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. The detriment that the state would impose upon the pregnant woman by denying this choice altogether is apparent. Specific and direct harm, medically diagnosable even in early pregnancy, may be involved. Maternity or additional offspring may force upon the woman a distressful life and future.
So obviously this case had a pretty powerful impact on society. For one, it had a substantial impact on public health in regard to reducing morbidity and mortality rates, because women no longer had to seek out these quote-unquote backdoor or illegal abortions that were often unsafe and led to serious complications. But the decision of the court did spark widespread controversy, and the tensions between what we call pro-life and pro-choice people rose significantly. So since the court had split the rules on pregnancy and abortion into the 3 trimesters, wherein the first trimester the state cannot impede upon a woman's choice, the second trimester the state may impose regulations, and the third trimester, once the fetus is considered viable, the state can regulate or even prohibit abortion as long as there are exceptions like preserving the mother's health. There was widespread controversy. And the question of when does life begin is often brought up in arguments regarding abortion, even today. So as for the legal implications of the case, the ruling struck down many U.S. state and federal abortion laws, including one right here in Georgia, and quite recently the Georgia Heartbeat Bill from Governor Brian Kemp, where the judges ruled the bill infringed upon constitutional rights that had been established in Roe v. Wade. So questions of abortion continue to be asked in a legal sense, more specifically the case of 1992 Planned Parenthood versus Casey, which I will get into in a second. So as far as similar cases go, one of them that I mentioned earlier is Planned Parenthood versus Casey, which happened in 1992. For some background information, basically Governor Robert Casey of Pennsylvania enacted a series of statutes on abortion, including a minor seeking abortion needs parental consent, married women must inform their spouse prior to an abortion, and that clinics must inform all women requesting abortions of options and wait 24 hours before actually performing it. So once Casey enacted these regulations, Planned Parenthood came out and said, no, we don't like this, and brought a suit against him. The decision of the court was 5-4, with the court ruling reaffirming Roe v. Wade in that women have a right to an abortion, but upholding all but one of Pennsylvania's provisions, that being the married women must inform their spouse because it brings an undue burden upon them. And an undue burden was a new standard that was brought in this case. And it basically said a law is invalid if its purpose or effect is to place substantial obstacles in the path of a woman seeking an abortion before the fetus attains viability. So basically, yes, women had a right to an abortion, but the court overturned the trimester setup. So if a state wanted to regulate abortion during the first trimester, they could, so long as it did not bring upon this new concept of an undue burden upon them. So for the second case, this case was Whole Women's Health versus Hellerstein, which was pretty recent in 2016. So some background for this case. In 2013, Texas passed House Bill 2 that contained regulations for abortions, more specifically restrictions and requirements for abortion clinics. For example, one of these requirements was that the physician performing the abortion would have to have admitting privileges in a hospital within 30 miles of the clinic. So these provisions forced the closure of many abortion clinics, forced women to go to unnecessary lengths to get one, like they had to wait longer or travel farther or pay more. And for some women, that situation was just not possible for them. So eventually in 2016, the Supreme Court ruled 5-3 for Whole Women's Health, and they stated that the Texas restrictions on delivery services for abortions were unconstitutional and imposed an undue burden on women seeking an abortion, a rule that they had established in the previous case mentioned, Planned Parenthood versus Casey. So basically, Texas had said they enacted this in the interest of making abortions safer and helping these women when, in fact, it just caused them more struggle because so many women were impacted negatively from all these clinic closures. So both of these cases are directly related to Roe v. Wade because, for one, obviously they deal with abortion, and they deal with how much say the government has on abortions. And if you notice, they all kind of piggyback off each other. So in Roe v. Wade, women can have an abortion. In Planned Parenthood versus Casey, the government can put restrictions or regulations on it as long as it doesn't impose an undue burden. And finally, in Whole Women's Health versus Hellerstein, how far does this regulatory power reach?
To remember Roe v. Wade, you can think of the R in Roe as the right of abortion given to woman, and think of the W in Wade as woman. So abortion is the right given to woman according to Roe v. Wade.